Hello everyone, welcome to our webinar on Schrems II, another hand grenade thrown into our lives by the EU authorities. My name is Chris Jeffrey, I'm a partner in the London office of Taylor Wessing, and I specialise in data protection and commercial contracts, principally for US headquartered businesses doing business in Europe. I'm very pleased to be joined by a German colleague. Paul Voigt is a partner in our Berlin office with a very similar focus to mine, and that German angle with the regulators tending to be more conservative and you might say more aggressive than in many countries in Europe. It's always good to have that German angle. So let's crack on if that's all right. Oh, I should just say, by the way, please do feel free to submit questions. You should be able to see that in your browser as we go, and we will do our best to leave time at the end to answer them. And to kick off, Paul will just give us a quick recap on how we got here.
Thanks, Chris. Before we speak in more detail about what happened over the last week, I think it makes sense to maybe take a step backwards and ask ourselves how we actually got here. And if we speak about Schrems II and the respective decision of the European Court of Justice, the two makes it obvious that there has been a Schrems I before, and the whole process actually started in 2013 when a mid-20-year-old Austrian law student and activist, Max Schrems, was not so happy about the way Facebook handled his data and the way Facebook sent on his data to the parent entity in the United States. So the Irish entity, which is responsible for Europe, sent personal data to the US entity based on the adequacy decision Safe Harbor, which was the predecessor at the time. And Max Schrems was of the opinion that this was not in compliance with European data protection law and approached the Irish Data Protection Supervisory Authority, the Irish Commissioner, and asked them to investigate this matter. And the Irish Commissioner basically told him, come on, your request is frivolous. We don't even take a look at it. It's so obvious nonsense that we don't even have to investigate. Look, there's Safe Harbor. We're bound by Safe Harbor. There's nothing we can do. And Max wasn't very happy about that and took the matter even further to the Irish High Court. And the Irish High Court, actually, if you read the respective judgment at the time, was actually quite positive about data processing in the US and was quite positive about the surveillance activities in the US, and even mentioned that this kind of surveillance surely saved lots of life and was very, very helpful for counter-terrorism activities, and only fools would be surprised by respective surveillance activities. But still, in the end, the Irish High Court had some doubts about the lawfulness of the respective data transfers based on Safe Harbor and brought the matter to the European Court of Justice, which in 2015 actually took down Safe Harbor, the adequacy decision Safe Harbor, but not because the European Court of Justice was of the opinion that the surveillance laws in the US have been outrageous. Actually, in fact, in 2015, the court neither took a closer look at the respective surveillance activities in the US, nor did they take a look at the Safe Harbor regime in itself. So they didn't even ask themselves the question, is Safe Harbor adequately protecting personal data? But they only looked at what kind of information did the European Commission gather before actually passing the adequacy decision. And the mere fact that the European Commission did not take a look at the legal regime in the United States and didn't even bother thinking about the surveillance regime in the United States. This was a reason for the European Court of Justice to take down Safe Harbor and basically saying, look, an adequacy decision has to have the respective surveillance measures in the third country in mind. You can't set up an adequacy decision without taking a look at those access rights by authorities. So what happened was that at the time the data protection supervisory authorities granted a 3-month interim period during which the European Commission could negotiate a new agreement with the United States, and that was a very hard process because obviously the European Commission was bound by the decision of the European Court of Justice, and they had to take account of the European fundamental rights and the fundamental right to privacy, whereas the United States obviously wanted to keep on continuing with their surveillance programs. So actually until a few days before the agreement was signed, it didn't look like it would have success, but in the end it had, because so it was claimed by the European Commission, the United States have provided sufficient safeguards in order to make Privacy Shield happen. If you took a closer look at the time at the respective documents that were provided by the United States, you had seen that actually no new evidence, no new documents had been provided by the United States, but the same documents that had initially been provided have now been considered sufficient by the European Commission just to make it happen. So not so surprisingly, in a second attempt, also the Privacy Shield was brought to fall now by the European Court of Justice. And this time, in 2020, the European Court of Justice actually did take a look at the specific surveillance measures in the United States and did specifically judge on these surveillance measures and was of the opinion that these surveillance measures in the United States would not have adequate safeguards in order to protect the rights of European citizens, and also the way those measures have been conducted have been regarded as unproportionate. Thus, the Privacy Shield is no longer applicable. The Standard Contractual Clauses, on the other hand, they have not been regarded as unlawful per se, but the court made clear that they can keep on being a solid basis for international data transfers, but potentially not on their own. So the court made clear that the Standard Contractual Clauses can only survive because they have a flexible regime and they can be adapted to the specific situation, and as the case may be, additional safeguards may need to be taken in order to allow for data transfers to third countries, including the US. So in the end, basically, you could keep on relying on Standard Contractual Clauses, but for data transfers in the US, likely not without taking additional safeguard measures, at least when data was flowing to US importers that would be subject to certain US requirements, such as Section 702 FISA. How these additional safeguards that have to be taken shall look like, there was a big question mark over the last month, and the European Data Protection Board has now come up with some guidance on what additional measures could be taken, and Chris will explain those measures in more detail now.
Thanks, Paul. That's a great introduction. So what have we got from the EDPB? We've got two sets of recommendations, not one but two. The main event, if you like, is the recommendations around the diligence that should be undertaken and the supplementary measures that may be necessary over and above SCCs, potentially over and above BCRs, we'll touch on BCRs later, in order for transfers to third countries, including the US, but obviously, as Paul says, not just the US, for them to be legal. Then the second, slightly lighter recommendations is meant to help with the third step of the Schrems analysis the EDPB expects companies to be taking, and that's an assessment of the local law in the third country. So you need both documents to nut through what the EDPB is asking of us. I mean, initial reactions, it may be a case of being careful what you wish for, because obviously we wanted to know what the authorities expect companies to do in the wake of the Schrems judgment. But it is one, certainly speaking personally, it's one of those documents that occasionally comes out of Brussels that has me with my head in my hands, because I think it's fair to say it's a purist and conservative interpretation of the law. We know that the EDPB feel they have no choice, that they're stuck between the requirements of GDPR and the Schrems judgment. But to be honest, for many of us who may have hoped for, a pragmatic and proportionate risk-based analysis to be recommended, it's a little disappointing. Certainly the initial reaction from the industry, above all in the US, as you might expect, has been disappointed that those principles of risk-based analysis and proportionality largely seem to be missing. One example, just to start us off, is, when I'm talking to clients, often we're saying, well, hang on a minute, let's keep this in perspective. The nature of the data that is being transferred out of Europe is often not the kind of thing the US authorities would be in the least bit interested in. That is not a factor you're allowed to take into account when working out what supplementary measures are required, and that's caused some negative reaction. Anyway, obviously we have some thoughts, and we'll share them with you on this webinar on how in practice you go about this to maximize your chances of doing what businesses need to do. But at some point, with the dominance of US tech firms, data so often ends up in the US. I don't think there's any doubt against that background that this makes the whole transfer piece a lot more challenging. Anyway, quick reminder on their legal status. It's draft recommendations with a consultation period just extended to the 21st of December, which means, of course, we won't see Europe. Being Europe over Christmas, we won't see a final version of these until January, but don't expect massive changes. The EDPB on an IAPP seminar said that they had the unanimous agreement of all of the European regulators around the table. So whilst, we would encourage anyone to take part in that consultation, I think the more views they hear, the better. I also don't think in terms of timing that you should hold off till the new year. I know you've all got lots of other things to do, but I don't think we'll get radically different guidance come January, so we should probably crack on, all else being equal. So it's not law, it's recommendations binding on the national regulators, not technically binding on the rest of us, but of course these things are hugely authoritative. When all 27 now member states get together, what their regulators say together carries a lot of weight. It will influence, no doubt, European customers of B2B services from outside of Europe hugely in negotiations and around renewals. And I know a lot of our B2B clients are getting ready for those questions coming through. So let's crack into the detail. This gives you a sense of what we're looking at. We have a 6-step process, and one practical recommendation would be that in your public-facing documents, particularly if you're a B2B vendor, but maybe for anyone, or certainly your internal privacy program, should, I think, be aligned with each of these 6 steps. Even where you've taken a number of them already, I would want to be optically aligned with them. Let's step through them quickly. Step 1, know your transfers, and I know privacy lawyers are like broken records about knowing your data flows, but this is another example where we're going to say exactly the same thing, I'm afraid. And just one observation from talking to a number of clients over the last year or so, often audits done for GDPR back in 2018, record of processing activities, etc., were, understandably enough to get something defensible done for that looming May 2018 deadline, back when that was what we were stressing about. And they either have been updated partially since then or not updated at all. So when we say know your transfers, be careful about just assuming that the third countries listed in your data audit or your record of processing will be enough. It's clear from the Schrems judgment, it's clear from the EDPB guidance that, for instance, they don't just want to know where you as an importer will process the data, or where the exporter will. They want to look down the chain to other controllers, processors, sub-processors to work out where in the world the data will be hosted or accessed from. So it needs a refreshed trawl, I think, is the bottom line. Now, of course, you're looking at that step one. If you've got a green if you're in the EU, flag from the reluctantly Brexiting Brit, if I can display my political opinions. You've got to treat the UK, I think, as a very likely to be a third country and not part of the EU or the EEA, whilst there's a chance we'll do a deal that may involve some kind of adequacy finding, a bit like the Japan Free Trade Agreement did. That can't be taken for granted. So for planning purposes, I think UK ? Would be in the third country category for now. Obviously, in the EU proper or in the EEA proper is fine. That works. That's not a data transfer for GDPR purposes. Where it is going to a third country, then we stepped straight into step two, which is identify your transfer tools. And I know this is Privacy 101, but it gets new and more interesting in a moment. So what's the justification for the transfer to a non-European third country? And of course, it could be a decision on adequacy. The whitelisted countries, there are 12. The main ones, Canada, Israel, Japan, Argentina, a few others. The exemptions, this is an interesting one. I think because traditionally we've either relied on Privacy Shield, and that hasn't been the most rigorous of regimes, or a lot of companies have signed SCCs and put them in a drawer. People have ignored the exemptions because making the transfer legitimate has been relatively straightforward. As it gets less and less so, following Schrems and following this guidance, it's always worth just pausing and thinking about those exemptions. They are unlikely to be your get-out-of-jail card, but it's just worth taking a thought, if you haven't before, about whether they might apply. They're quite narrow, so I think that's the caveat. There is explicit consent, although the regulators don't like consent for systematic and repeated transfers. There's an exemption where it's necessary for the purposes of a contract with the data subject, and there's some debate about whether some B2C companies, for instance, who are based outside Europe, can take advantage of that, and actually different European countries take a different view. But anyway, that it's worth just thinking about that in case that can really help with this analysis. Most likely, though, we're talking about SCCs. Some companies may have BCRs. I think the same analysis applies. But we're going to assume that SCCs are in place. And as Paul said, they're not enough in themselves anymore. We can't just sign them, do some internal policy and process around them, and then put them in a drawer. We've now got to do some additional assessment. So straight into step 3 on the slide. And this is where I think it starts to get unrealistic, because the ask of companies, whatever their size is once they've identified the third countries which are not adequate, but where their data will be transferred, they're meant to do a detailed analysis of the law and practice in each transfer country. So if you just pause there for a moment, you could be a small or medium-sized company. To be honest, it's quite painful for larger companies too. You could find, you're based in Europe, you use a handful of global cloud providers, maybe a CRM, an HR platform, global payroll, the kind, the usual run of things. When you go and find out, if you don't know already, where they host, perhaps they have a support arm in India, perhaps they back up into China. You do find that from occasion. Maybe there's a hub for the Far East in the Pacific, in Singapore or Australia. You can find you've got a relatively long list of countries, and you're actually meant to go and assess whether their law and practice hits the European standard. So I think the practical point for us here, at least my initial view of this, is that for most companies, this bit of the analysis needs to be kept relatively short. And perhaps the main reason for that is we know from the Schrems judgment that whether we like it or not, and whatever hypocrisy from the European countries may be involved here, the US does not hit the requirement for US law. And it's not recommended to pick apart the Court of Justice decision and say, actually, we disagree. We think that US is perfectly adequate. That's just not going to fly. And because of the dominance of US in our tech world and the cloud, I think most companies will find some of the data is going to end up at some point in the US. So even if you find there are transfers out to Singapore and China and Australia, etc. as well, if it's going to the US, we know their law and practice is not going to hit this standard, and therefore we know we're straight into the next step and looking at supplementary measures. If you've got to do that for the US, in my view, you may as well shortcut the analysis elsewhere and roll out the same protections in those other territories. I know that's very high level, and there may be particular facts or internal transfers where actually you think, perhaps you'll look at an Australia and think, well, perhaps with their privacy law, there are enough protections around law enforcement and intelligence agency and access. Maybe we can argue with a straight face that actually the law satisfies the requirement. My worry is, I have to say instinctively, that it's quite unlikely we'll find any country who hits these requirements, particularly where most of the larger European countries don't. It's just that they don't fall to be assessed under these rules. So what I'm hoping for will come in practice is that there will be summaries, whether it's data guidance or OneTrust or law firms like us, where you don't need to spend weeks and a lot of money and resource assessing local law and practice. But the flag is that analysis does need to be in there somewhere. So even if we're shortcutting it, we still need to be shown to have done it. And the reason we need it is that the supplementary measures must be responsive to the inadequacies in local law and practice. So even if we're not going to do a massively detailed analysis around that, you can't just miss out stage 3 and jump straight to stage 4. I think that would be too risky. So let's jump through. Let's assume we've got a bunch of third countries where we need some supplementary measures and what that might mean. Well, the measures are of 3 broad kinds. The first is technical, and this is where we expect most of the action to be. And the reason for that is the EDPB recommendations make it clear that where the third country has law and practice which does not hit the European requirements, as for instance the US does following the Schrems judgment, there are no circumstances where merely contractual measures, so adding to the SCCs between importer and exporter, or having some kind of separate agreement which tries to plug the gap, or just organizational measures like internal policies, those will never be enough on their own to be sufficient supplementary measures. So once you get to step 4, you're always going to be looking at technical measures. Things like encryption, pseudonymization. They're not exhaustive, so we might look at data minimization and access control and all those secure deletion, minimal windows of access for support teams in third countries. There's a whole bunch of stuff that we're starting to think about, some of which is in the recommendations and some not, which we think will be grist to the mill. And I think the trick here will be it is probably impossible for transfers to comply with the strict letter of these recommendations. And we'll come to one of the main reasons for that in a minute. So as often in GDPR, no one's aiming for perfection. We're just aiming for good enough, and the judgment calls come in working what that is and how it means different things for different businesses. But I can see a decent and defensible Schrems remediation project having a sensible pick and mix, if you like, from the technical, contractual, and organizational measures. So before we get on to the technical ones, which is where I think most of the action is, the contractual ones are they're subdivided. So you could have an obligation to take additional technical measures, for instance. We're seeing in the marketplace already that vendors are looking to enhance the level of detail they give around security measures in the existing SCCs, and sometimes in DPAs, even when SCCs aren't being used. Other contractual measures might be around transparency. For instance, looking at how the law enforcement requests should be notified to the data exporter where it's lawful, of course, and maybe even challenged by the importer. Paul will talk more about the local SCCs, but I think an important practical takeaway is, even though they're in early draft form, they are the European Commission's idea of the kind of contractual measures. And they include transparency, they include stuff around the data subject. So even before they're finalized, they might be a useful precedent clause bank for the kinds of things you might want to put in interim SCCs to show your supplementary measures. If you've got a deal with a European customer, if you're a platform closing at the end of the year, or you want to upgrade your internal transfers before we get the final version of those new SCCs. I know some companies are looking at that. And then organizational measures, again, no magic in here, nothing particularly new, but they are policies around dealing with law enforcement requests, or an internal policy about how you go about assessing a new third country. So that might be part of opening a new affiliate in a new country, for instance. It might be an additional element to a vendor due diligence policy, where you ask, obviously, the question, where do you process, where do your sub-processors process, and have a clear policy that sets out the stakeholders and the questions that are gone through and the forms that need to be filled in, so you can show that accountability. Those are the kinds of things. The recommendations are relatively readable, to be fair. They're 38 pages, but it doesn't take too long to go through them. And I recommend you do if you are wrestling with this. So let's get on a little bit. So I'm ripping through here because I know we've got quite a lot to get through. One of the extraordinary things, I think, is on the right of this slide, is the now infamous use case 6. And so what the recommendations do is they give a few examples of where technical and other measures may help, but they also give examples of where technical and any other measures do not help. And perhaps the biggest example of where I think a lot of people have felt this is not realistic recommendations is the fact that where European personal data is accessed from a third country, let's use the US as the most common example, by a processor who occasionally needs access to the data in unencrypted format, that the EDPB has told us, as law and technological measures available stand today, that transfer can never be legitimate under GDPR. It really is that stark and that bold. And regardless of the nature of the data itself, the period during which unencrypted access is required, and the other protections that may be put around it. So that really everyone shot up in their seats when they read that, because I think it'll be clear what the implications of that are. Because if I think of the platform providers that we act for, typically for support to happen, sometimes for analytics to happen or customer reporting to happen effectively, it may be that data that encrypted in transit, which should be a tick in my view for these supplementary measures, it may be encrypted at rest by and large, but in some circumstances need to be decrypted. That of itself in the EDPBs means we've got a problem that we cannot surmount with other supplementary measures. And so I think, so what do we do about that? Do we all go home? Do transfers to the US stop? I think almost certainly not. And we have, of course, been here before. Every now and again, another data transfer hand grenade, whether it's the death of Safe Harbor or now the death of Privacy Shield, and now these guidance come in. The reality is what we expect is that market practice will settle at some way below the very, very high watermark set in these recommendations. But clearly it's not helpful to companies. The European regulators are setting their stall out in this really quite conservative way. I guess slightly more positively, encryption, which of course is often employed, pseudonymization, which is often employed, all these are helpful. The caveat to people who encrypt is that the recommendations are clear, that the encryption key should always be held by the exporter. And I think the fear there is if it's held by the importer could be compelled under local law to disclose it, and therefore the encryption is vulnerable. So you can see it's really quite a conservative approach. And as I say, I think my view is that you align with this as best you can. I think a lot of clients and companies are taking some of these steps already, and so a lot of it, I think, is picking on those easy wins. For other clients, when there's a conversation with the engineers or with the CISO, often what we find is some of the measures here are things they were thinking about from a general risk management perspective anyway. Maybe it was picked up on an ISO audit or a SOC 2 report to a customer. So sometimes, and let's try and be positive about this, you are pushing at an open door internally. But I do think it's almost certain that to be defensible under these recommendations, most clients will need to be making some changes to how they operate. And then so the next two are a little bit less substantive. Before we get on to the takeaways, procedural steps are, for instance, as clarity, you don't need to file the new SCCs unless you change them, but if you do, you would need to file them with the authorities. The same logic we know applies to BCRs, that there is still a responsibility to assess whether the actual transfer that's happening is adequate. For those of you who are thinking of BCRs, the recommendations say that the EDPB will be issuing further guidance. So at present, it's not really clear whether applications that are in train now and new applications made will be subject to a Schrems-driven assessment of the actual transfers. I would have thought logically they are highly likely to, but it isn't quite clear how this stuff impacts on BCRs yet. And then step 6 is regular review. So no timeline. This is really standard accountability stuff, I think. There's no specific timeline laid down here, but it gives examples like, if the local law has changed. So, even if you've decided law and practice doesn't hit EU standards, therefore we are going to adopt the following supplementary measures. They are designed to fill the gap between the law and practice and the European requirements. If the law changes to further weaken the protections of data, then the theory is that you should go back and reassess what further supplementary measures are taken. Now, whether that actually happens or not, I do think it's really important from a general governance perspective, but also from aligning to the maximum with these recommendations where we can, given that I think the vast majority of organizations will necessarily fall short, that there is a regular review, I would suggest at least annually, in there. So key takeaways before Paul gives us some light relief with the new SCCs. Don't panic, get busy. As always, we get these issues in European privacy, and actually usually they're not as bad as they seem once you start working through. unless you can anonymize or silo or stick to the EU and whitelisted countries, and that any of those have their own challenges, as I'm sure many of you know, then there is no quick or easy fix. I do think that that's the case. Maybe in a year or two's time, there'll be sufficient market practice that you can almost take a bunch of supplementary measures off the shelf, but it'll take us a while, I think, to get there. And this is a real and increasingly hot area, and will be in the meantime. Keep the law and practice review, that step through light. I think that's for most people, unless you see the chance that you can actually say, I don't need supplementary measures. If you look at this country's law, they are close enough to the EU standards that I don't need to worry. Although, as I said before, I think if the US doesn't pass, I question whether any country will. So I worry about companies spending too long on that legal review. Align with the steps, look for the easy wins, because many of you will be doing some of these supplementary measures already. So where you can build on what you've already done, I think that just obviously makes the lift a little bit lighter, and would be easier on everyone. It would mean less of a lift for the engineering team, etc. And getting their time is usually challenging with a full roadmap. Technical measures are where the action is, and I would adopt a risk-based approach, but be discreet. In other words, I do still think it matters in terms of practical risk, what the level of sensitivity, what the nature of the data is. So whilst we can't be saying in our Schrems analysis that we need to document in the usual GDPR way, we can't say, we've only done these supplementary measures because we don't think the police would ever be interested in this data. That's not what the regulators want to see. I think in practice, lower risk data will attract a lower level of supplementary measures, and that's just the reality. And the ICO in their classic way, I know they're no longer part of the EDPB, but in their announcement they said that they were keeping an eye and going through the guidance and the recommendations, but we continue to adopt a risk-based and proportionate approach to our oversight of international transfers, which I thought was at least reassuring that their approach will remain the same. And to compare and contrast, Paul, can you tell us a little bit about how the German regulators have reacted to the recommendations?
Sure, I'd love to. And actually, one fun fact, also the two, I'll go back to the slides, the two use cases here that you mentioned are the ones of most high practical relevance, apparently have been implemented or proposed by the Germans. Yeah, I think a big thank you to the German authorities for bringing in such practical examples. Actually, we're seeing some, I don't know how you can call it, balanced approach or maybe a deviating approach. So, for example, Microsoft has just recently amended their data processing agreement, I think in force from December onwards, and have included a few Schrems II safeguards, limited provision of data to authorities, transparency, damage rights for the data subjects, and the authority in Baden-Württemberg in the south of Germany, which are generally, like in the south, they're usually a bit more relaxed from a privacy standpoint. They immediately handed out a press release saying, okay, maybe not every problem is solved, but way to go, really great. No, we don't have big concerns anymore. And just a few days later, the Berlin authorities, and like in the north, we are known for being a bit more conservative, have responded and basically saying, super ridiculous. Why didn't the Baden-Württemberg authority read the additional measures before giving a comment? That doesn't make any sense. No safeguard whatsoever. So they're actually fighting in public around this, and I think it will be interesting to see how this goes forward, because, to be honest, no one can deal with this guidance. Yeah, you can't, as you mentioned, you can't just stop data transfers to the US, and even if you try to do it, and for example, use European providers, they usually will have US providers in the back end, so it will be difficult to actually find a way out. But maybe the new standard contractual clauses are a way out. So let's take a closer look. And I don't know why I can't switch to the next slides. I don't know, Molly or Chris, whether you see something?
I see new standard contractual clauses.
Yeah, me too. I can't switch further. Can you try, maybe? And I'll already start speaking. The European Commission has handed out draft new standard contractual clauses, which were supposed to be finalized end of the year, but now potentially this may take until beginning of next year, and they're up for consultation for the time being. And the interesting thing about these new standard contractual clauses is that they basically consist of 4 different modules. The first one being controller to controller, and this is something we obviously know already. We have been having controller to controller standard contractual clauses since 2001. And these controller to controller clauses, they put a bit more flesh to the bone, if you like. So whereas the old standard contractual clauses have been relatively vague and just gave certain principles on how to deal with data, the new ones are much nearer to GDPR and have quite specific GDPR-style requirements in there. Then we have controller to processor clauses, and also these clauses we know them. We've had them since 2010, at least in the current version. But the issue that we had so far with the controller to processor clauses was, we had several issues with them, but one of them was that they were drafted under the EC Data Protection Directive, and under this directive, the requirements for getting a processor in have been lower than they are now under GDPR. So the very specific, very broad requirements for concluding a data processing agreement with data processors, as we know them now under Article 28 GDPR, they are not implemented in the current standard contractual clauses controller to processor, and additional data processing agreement needed to be concluded when you wanted to get a data processor in. This shall no longer be necessary under the new clauses. Interestingly, and I'm sorry that you can't see my slides, Chris, I don't know why it's not working. It worked a second ago, but anyhow, as a third module, we now have processor to processor clauses, and this is something that was desperately needed in practice. So far, if you were a European controller and you engaged a European processor, and then this European processor engaged a non-European subprocessor, basically the European processor, the only thing they could do is conclude standard contractual clauses controller to processor with the subprocessor, knowing that this does not really fit, but there was just no other contractual framework available, and the authorities had been of the opinion that in this case the controllers in the European Union were obliged to have standard contractual clauses with all sub-processors outside the European Union in place, in addition to their contractual arrangements with the processor in the EU, making it, of course, super complicated to deal with the whole process. This shall be facilitated by the new processor-to-processor clauses. And finally, we have new clauses in there, processor to controller, which is interesting. Those clauses are made for data transfers from a processor based in the European Union to a data controller based outside the European Union, which seems a bit odd. The question is, do you actually need that? Yeah, I mean, because the question is a data transfer from a processor that is engaged by a non-EU controller actually a data transfer in the meaning of Chapter 5 of the GDPR? Do you actually need safeguards for that? I would say that is at least questionable. But even if you would say this is required and you need respective safeguards, the safeguards that are proposed by the Commission, I don't know whether they really make sense. For example, in this scenario between the controller and processor, what you would definitely need would be a data processing agreement. But this is not part of these clauses. This needs to be concluded separately. other requirements are there. For example, the controller may, under certain circumstances, need to delete all the data they have received from the processor if the agreement with the processor is terminated. Yeah, and I would also argue it's questionable whether that really makes sense, in particular if the controller outside the European Union is not subject to GDPR, which may very well be the case. So in a nutshell, quite a few interesting changes. It's good that we have these processor-to-processor clauses. It's good that we don't have to conclude additional data processing agreement besides of the standard contractual clauses. What is also interesting is that we now have specific hierarchy requirements or rules in the standard contractual clauses. So the standard contractual clauses shall always supersede any kind of other agreements that you have besides the standard contractual clauses. So if you have an MSA in place, for example, that has in their specific deviating requirements, they will be superseded by the standard contractual clauses, which will be particularly interesting also with respect to liability, because the clauses also have a liability and an indemnification clause, and very likely the liability clause that you have in your MSA or other business agreement besides the standard contractual clauses will likely not apply to the same extent to data transfers under the standard contractual clauses. Chris, have you been able to switch the slides?
Yeah, I can now. Where are you?
So I'm on, I think, slide 16, new standard contractual clauses relevance with regard to Schrems II judgment.
Yeah,
okay. Okay, wonderful. So the new clauses do have some wording on with relating to Schrems II as well, which is quite interesting. In particular, they have specific requirements. What happens if a foreign or like a third country authority approaches you and requests access to data? Then there are certain requirements in clause 3 of the standard contractual clauses, basically requiring the data importer to act transparently, to inform the data exporter of respective requests, to minimize the data that they provide to the authorities, etc. So quite a lot of the requirements that companies also chose to conclude or try to conclude with data importers outside the EU frequently, so that may be helpful in that regard. And let's see whether it works now. Yep. But there are also a few things that are a bit maybe strange, if you like, or at least may be a hurdle in practice. So one, for example, which is interesting, the standard contractual clauses shall only apply with respect to data transfers to importers that are not subject to GDPR, which sounds logical at first, because, I mean, that is what the standard contractual clauses are there for, implement an adequate data protection level at the data importer outside the European Union, because we assume they don't have the same level of privacy as we have in the European Union. However, quite a lot of those importers will actually be subject to GDPR due to the principle of destination of GDPR. So if a company outside the EU provides goods or services to people in the EU or monitor their behavior, the GDPR may apply to them directly. But the way the clauses are currently drafted, respective data transfers to those third country importers would not be covered, which is strange, because basically all EU supervisory authorities, apart from the ICO, who takes a bit more pragmatic approach, are of the opinion that those transfers need to be justified and require actually additional safeguards. Interesting is also that I mentioned we have processor-to-processor clauses, which is good, and which in particular in relationships with many parties involved may facilitate things. What is a bit annoying, though, is that in those relationships, the controller apparently always needs to be part of the respective agreement, as you can see from the signature lines. So basically, whenever a processor brings in a new client, a new controller, they will have to notify the sub-processor. They will have to tell them who is the new client and what do they actually do for them, what kind of data do they process for them. So that makes it a bit difficult to handle in those multi-party situations. So the agreement needs to be constantly updated and new parties will have to be added, and the sub-processor gets full insights into the client relationships of the processor, which is maybe not ideal neither. I mentioned that we have some requirements with respect to Schrems II and the clauses, and one very important one is Clause 2, and basically Clause 2A requires you to do as Chris already mentioned, some kind of transfer impact assessment. So basically what Clause 2A says, that the parties have to warrant, so they have to actually warrant and document their respective assessment and make it available to the supervisory authority at the request of the supervisory authority. They have to warrant that they have no reason to believe that the laws in the third country of destination prevent the data importer from fulfilling its obligations under the clauses. And this is, again, based on the understanding that laws that respect the essence of the fundamental rights and freedoms and do not exceed what is necessary and proportionate in a democratic society shall not be in contradiction with the clauses. If you take this clause and look at the United States, and in particular at data importers in the United States that are subject to 702 FISA, basically we have the answer for this assessment already because the European Court of Justice gave it to us. So it is very questionable to what extent you can actually transfer data to the United States based on these new clauses. I mean, it's a contract and you can interpret a contract and you can always find a way to interpret it a bit more broadly, and in particular Clause 2B gives you also some possibilities to interpret this a bit more broadly in that regard, because with respect to this warranty you can take into account the specific circumstances of the transfer, the number of actors involved, the absence of requests for disclosure from public authorities in the past, but also potential technical safeguards that you have taken to protect the data. Still, all of this, at least from the wording of the clauses as I read it, does not really provide you for a possibility of a risk-based analysis of the transfer, so you don't have to assess the risk of the specific transfer, but you actually have to assess the law in the third country. And I'm not saying that you have no wiggle room at all, but I mean, the law doesn't change just because you have implemented additional measures. The law in the US will remain the same. So this Clause 2A, I would argue, is quite a bit of a shock relating to data transfers to the US. In addition to this assessment that you have to do at the beginning of the contract. So at the beginning of the contract, you have to look very, very strongly at the law of the data importer, but potentially the law of the data importer may be super fine at the beginning and 100% in line with European requirements. And by the way, if you look at, for example, the court cases in the past relating to data retention in the EU, whenever there is a data retention law, basically the courts struck those respective laws down and said, look, this is not in line with European fundamental rights. So if even the EU is not in line with these requirements, it will be difficult to find countries outside the EU that actually are. But let's assume you have found a country and that is perfectly fine and they don't have any authority disclosure rights. But this changes after time. For example, because the law in the respective country changes, then at this point it will be possible to have a more risk-based approach involved. In Clause 2F, basically you have the possibility to assess whether you can take additional, like, for example, technical measures or organizational measures by basically claiming, look, I know the law has changed, the law is not adequate anymore, and I should stop the transfer, but I don't because I have put additional safeguards in place, and these additional safeguards protect me, and I don't need to stop the transfer. However, even in this case, you will have to notify the Data Protection Supervisory Authority, which obviously is not ideal neither. Yeah, so much with respect to the Standard Contractual Clauses. Those are in draft only for the time being. They're up for consultation until mid-December, and probably relatively shortly afterwards we will see a finalized version of these SCC, of these new SCC, and then we have a 1-year period in which you can still continue using standard contractual clauses that have already been concluded, but within this period of 1 year you will have to switch to the new clauses. Yes, that's a short run through the standard contractual clauses. Happy to take any questions you may have in that regard.
And Paul, quickly from me, I'm sort of assuming that Q1 of next year, European customers buying technology where there's a transfer outside of Europe, they're going to opt for the new SCCs, aren't they? They're going to push quite soon. I don't think there'll be a relaxed, gradual moving over the course of 2021. I'm rather assuming and it may be on renewal or new customers signing up, but vendors are likely to need to have a version of the new SCCs in good shape pretty quickly next year.
Yeah. So I mean, basically, this grace period only applies to existing agreements. It does not apply to new agreements. And even for existing agreements, I mean, what we are seeing now, the European exporters that have a bit more advanced privacy programs, they try to push non-European vendors into signing additional agreements like Schrems II appendices or something like that to the standard contractual clauses to have certain additional requirements in there, and we see some of them backing off now because they say, look, it doesn't really make sense to strongly negotiate this kind of additional requirements if they're basically in there in the new standard contractual clauses anyhow. Then I'll wait 1 or 2 months and just request the vendor to conclude the new standard contractual clauses.
Yep. So one question we've got, and I'll read it out. If our MSA data protection limits are now superseded, how do we bring those back in line with risks agreed? And I think, Paul, this is going back to the point you made that it looks harder than it is at present to justify floating on top of the new SCCs a liability limitation, whether that's set at the annual value of the contract or a multiple, or perhaps, as you sometimes see, a kind of super cap, which could be in the low millions.
So from my understanding, I would argue, yes, this will become much more difficult. I mean, the old, for example, the 2010 clauses, they also had liability requirements in there, but those mostly refer to liability vis-a-vis the data subjects. The new clauses have liability requirements also among the parties, and the new clauses have a specific, I would argue by law the standard contractual clauses should have always superseded other requirements, but obviously that was not always so explicitly in the agreement. Now it's explicitly in the standard contractual clauses. We have a liability clause and we have a respective hierarchy clause, which will make it more difficult to argue for respective limitation, in particular with respect to the data transfers.
And I think for vendors, and I think this question is probably at a vendor, I think we're not saying it's 100% cast iron guaranteed that you cannot, and it will be completely ineffective, to limit liability in your MSA where it arises under the new form of SCCs. But I do think it's going to be a much harder discussion with customers for vendors, and there is a genuine risk that if this ever reached the European courts, that they would say, no, it's quite clear that the liability of limitation conflicts with the allocation of liability under the SCC. And the hierarchy clause, as Paul says if there's any conflict between the new SCCs and any other agreement, whether it's signed at the same time as the SCCs or any time later, the new SCCs will govern. So I think, but as a practical point, I don't expect vendors are going to do anything radically different. I think the risk profile has changed, whereas we'd be reasonably confident, I think, certainly from a UK perspective, that a cap that's agreed between two businesses, even if it caps liability under a DPA or the current version of the SCCs, should be good. There are some niceties around how they're drafted, but generally courts in the UK are reluctant to disturb them. I think there's a higher risk here. So I think it is about looking back to insurance. I think it is about being a little bit more careful and perhaps open in the discussion with the business that the practical worst case risk here is actually shifting materially with the new SCCs. And Paul, one other question I can see. Do you expect German customers, if they're negotiating now, if you had a large German customer with those stressful regulators breathing down their necks, are they likely to insist that there's very little transfer to the US, or that the recommendations are followed to the letter? Or are they just going to want to know that a vendor is on it and going through the 6 steps and being sensible?
Yeah. So I would argue, they're not all the same, yeah. But I mean, everyone, including the regulators, know that there's no easy way out for this. Yeah, and to the extent that you do provide your data to a third party, or that you do provide, for example, data into the cloud, or even within a group, yeah, you provide data access within a group to, US parent or something, there is just no easy way out. And even if you use a European vendor, the European vendor will also have sub-processors involved that are often from the US. So what we see is that also quite a few clients are looking for a reasonable explanation why they can sign the deal. Yeah, and what we see is that if the vendors are not comforting this at all, and basically say, look, this is our standard DPA, everyone else loves it. And by the way, the European Court of Justice, we read it all the time. The European Court of Justice says the standard contractual clauses still work. We use the standard contractual clauses because you only get response from their sales teams and not from their legal teams. This may actually be difficult from a business perspective also, because at some point in time maybe the European customer or the German customer will say, no, okay, we don't want to do the work then. But if you are a bit comforting and at least have specific measures in place, etc., most of the European customers will accept it. That is my feeling, because they know there is just no way out. Yeah? There is no measure that the vendor can take to prevent this from happening. And this is also what I find a bit frustrating about the EDPB guidance. Even if you want to do everything right, even if you really do your best, you negotiate an agreement with the vendor, you put in organizational measures and you put in contractual measures, and everything is encrypted as far as possible to the extent that you use a cloud service. In 99.9% of the cases, the vendor will need access to clear data. And if the authorities say, look, I don't care, you please, yes, take organizational and contractual measures, but I don't really care if it's not only you that holds the key, dear exporter, then it's not valid. I mean, then why bothering in the first place?
I think we're on the same page there. That's a bit crazy. But I guess what that means is that, good things for perhaps on the vendor side to be doing and on the customer side to be asking is, looking for that reassurance that you're on it, that you're going through the 6-step process, and having, and I know these have been used in Germany in particular, an interim set of SCCs that have some of the contractual measures we've been talking about in this presentation, perhaps enhanced reassurances around law enforcement requests, or readiness to negotiate in good faith, additional, the new SCCs when they come out. There's a number of ways, I think, that you can hit a kind of halfway house in the interim that, with a bit of luck, for most European customers will allow the deal to get over the line, even though it will take some months, to be fair, I think, for a lot of businesses to step all the way through that 6-step process and have all their supplementary measures in a row. Okay, well, I can't see any more questions, and we're a little bit over time, but thank you, everyone, for attending. Sorry about the slight glitch with the freezing of the slides. Appreciate we've gone through a lot there. I do hope it was useful. I know it's a very topical issue. Do let us know if Paul or I or both of us can help answer any specific questions you have, and we look forward to seeing you on our next webinar. Thank you very much.
Definitely.